Okay, I see some new faces or new names, so welcome aboard. Very quickly, we're going to cover 2 topics today. The one we're going to start very briefly with the liability issue. That is not deeply discussed here, but it's like a sub issue that you may have to discuss in most of the questions. So I'm going to quickly browse through that, and then we're going to quickly move on to sexual offenses and rape law. Okay. Now, so first of all, I did look at the exams. Whoever sent me the exams, I do not have your feedback yet, but I will upload the sample answer by tonight, and you guys can look at it, and I will send you the feedback, personal feedback through emails. Later on next week, if you like, we can do a quick feedback session, like for 10 minutes or 15 minutes in the beginning of the lecture, and then we're going to go on and continue with our lecture. Okay. And like Ms. Ujala in your contract lecture shared with you the website and the Q&A book, I will suggest the same to look at that website. It's a very good resource to look at if you want to make a handout of your own and you want to look at the sample flashcard from somebody else, notes. It has some case summaries too. That doesn't have everything, but it has most of it. When I prepare my lecture, I read that, and when I send you my case summaries, I often include that part of I often include a lot of summaries from that website too. I do, however, add my own notes and my own graphs and stuff in the document that I sent you. Hopefully everyone looked at the homicide case summaries and summary of the topic that I posted online on Facebook. If any of you guys who have recently joined have not looked at it, please go on and join the group, and you should be able to see the document. And also the question, if anybody who has not attempted the question and would like to do so, please do it by tonight. I'm going to start sending the answers back by tonight, so you should start getting your answers back tomorrow. Okay. Okay. What is liability? Quickly, liability is something. Question is on the Facebook group. Let me give you the link. If you have not joined the group yet, I suggest you should go and join it. Give me just a second. Let me pull it up. Here is the link to the document and the question, and it is in that Facebook group called UOL Criminal Law. If you click on it, it may ask you to join the group, so go on and send the request to join, and somebody will accept very soon. Other than that, there is another group, that's a general group for University of London. And it's this one over here. Here. Go on and join both of these groups. I don't think anybody is now here that is not on Facebook. So if you have any problems looking at or finding the question or other documents that are on the group, please let me know. My email address is posted there too. Some people were requesting for the email address earlier, and a couple of days earlier. All right, so we're going to move on to liability. Criminal law deals with 3 types of liability. These are the major forms. It's called strict liability, vicarious liability, and corporate liability. When we read homicide, there was also a corporate liability section there, which is very, very, very brief, and I believe subject guide did not discuss that. We're going to go through that today. It's very simple, very easy, and Strict liability is a concept that you will also read in torts, and you will read about it in torts very heavily. Okay? There are certain offenses that are the strict liability offenses, and for that, court imposes liability on the defendant in certain circumstances. For example, first of all, it is defined as the offense that do not require the proof of mens rea in respect of at least one element of actus reus. You know how we have prosecution has to prove all the elements of the crime, that includes the actus reus element and the mens rea element. This strict liability would be that at least one element of the actus rea. They do not need the proof of mens rea for it. However, proof of mens rea may be required for some of the elements of the actus reus. Okay? Majority of strict liability offenses are regulatory offenses provided by statutes, govern issues such as statutes or acts or any law that is issued by the government or the court, higher court. The issues that are governed under strict liability are generally health and safety, pollution, food safety, road traffic, licensing, all these kind of matters that come under the number of governments usually are called the strict liability offenses. Okay, so although some strict liability offenses carry the possibility of sentence of imprisonment upon conviction, many of these offenses are relatively minor and calls for imposition of fine. Most of the time, there is no serious imprisonment for it, but for example, you get your license suspended, meeting license suspended, or for example, you broke a law that was written in a statute, you will have to pay the fine. You didn't get the permit for opening a restaurant or something. You'll get a fine, and you may get your restaurant shut down until you get the your license or your permit in force. Okay. There are some serious offenses of strict liability, such as child rape of the children under 13 years of age, assault occasioning and bodily harm. That is the Section 47 offenses against the Person Act 1861. Those offenses that are mentioned in there are the strict liability offenses. It can also be described as strict liability because only element of mens rea required is that that relating to assault or battery, and the mens rea is required is in relation to the degree of harm caused, not necessarily the actual offense itself. Okay. You will read it in great detail in torts, but don't mix them together. If you are asked about what kind of liability it is, or your fact pattern says the licensing is suspended, or it talks about some of the strict liability offenses, then do not discuss tort. Always discuss only crime. You can, however, for an extra point, mention that it can be in tort, however, but don't go into detail on that. Stick to the point, stick to the criminal law. Okay, why strict liability has been the subject of discussion for a while. People give arguments for and against strict liability. There are certain arguments for strict liability. For example, there's public protection, easier to prove, and small penalty. And they say that the imposition of strict liability is necessary for the protection of public. It generally related to regulatory offenses, encouraging greater vigilance and safety, and deterring incompetence and unsafe behavior. Okay. Strict liability offenses are easier to prosecute as they do not require prosecution to spend time and effort proving the mens rea element. If you guys give me one moment, I'm going to check on the recording that Sammy mentioned. He said the recording is not, it's paused. Let me go on and check for that. Okay. I'm back, and it's good, Sammy. It's recording. fine. Okay, quick recap of what? All that was said? All that was said is that there are three major types of liability. It's called strict liability, vicarious liability, and corporate liability. Strict liability offenses are those that are embedded in the statutes or the laws that are issued by the government or the higher codes. Mostly what it is that they usually uphold a small amount of fine, but that is not necessary. Most of the time, strict liability offenses do not hold any imprisonment. The recording is just fine. When you listen to the recording or the video again, it will be uninterrupted. Okay. Moving on to the arguments for strict liability, as I said, it is the people who give argument for strict liability is that it's important and necessary for protection of public. It generally relates to regulatory offenses and thus encouraging great vigilance and safety and deterring incompetence and unsafe behavior. So, for example, you need a license to place a cart on the sidewalk during the fair. If you don't have a license, the government or the people or the police or people who are regulating the fair, they may not be able to put some safety signs or directions there, and somebody can get hurt. It's just to give a simple example. And that's why if you don't have a license, you will be held strictly liable because statutes mandated it. You did not get the license, and as a result, somebody had or could have been injured. Okay. Okay, what else? Also, that strict liability offenses are easier to prosecute as they do not require prosecution to spend a lot of time and effort proving the mens rea of the element. They can just prove that you don't have a license, and boom, there you go. You gotta pay this fine. Okay. As most strict liability offenses are regulatory only and not truly criminal, they carry only a minor penalty of perhaps a fine. The imposition of strict liability for imprisonable offenses are rare, and as such, there is generally no danger of sacrificing an individual's liberty without proof of mens rea. These are the arguments that people who defend strict liability, any lawmakers or whoever defends strict liability, give for strict liability. Okay. However, there are people who do not like strict liability offenses and they do not like the punishment or fine for it. And the arguments they give against strict liability is that the act does not make a man guilty of crime, okay, unless his mind also be guilty. This is the requirement of criminal liability derived from Latin maxim. That is the translation of it as the violation of actus no facet reum nisi mens sit rea, which means what I just said, that act does not make a man guilty of crime unless his mind also be guilty. So they say if there is no mens rea, there is no crime. He cannot be punished for a crime if he didn't intend to. Right? And this is the requirement of criminal liability that this says. Now, according to Lord Hailsham in Huntington versus Smith, 1975, strict liability violated this maxim. The imposition of strict liability can be unjust and contrary to the principle of fairness. Okay? A defendant in certain situations who has taken all reasonably practical steps to avoid liability may be strictly liable. So that person who was going to place a cart on the sidewalk or by the curb in the street during the fair, he may have been very, very, very careful. He may have a bright color cart. He may have all the flags and everything written on it, whatever he could do to make the public aware that there is a cart sitting here. So watch your step. Don't bring the cart around here and don't park very close to the cart. If somebody out there, a kid who is not used to of that cart over there, or he did not have any warning, he just go and runs into that cart and get hurt. Yeah, the man who has the cart, he's going to be strictly liable. So they say it's not fair because he has taken all the reasonable steps. He was very careful, and yet the kid got hurt, but it's not really his fault. It should be kid's fault, right, in a way? That's what they say, that it's against fairness. Okay, what else? Although a small penalty, defendant may still be punished by the stigma. They say it's a stigma. Once you are fined, once you are called that you violated the law, once you're called a criminal, you'll always be a criminal. They say it's a stigma for somebody who only may have paid just a $10 fine, not 10 pounds of a fine for placing that card without the license. But in the record, his name is going to go in the record, may or may not go in the record, but the people will always know him as, oh, he's the guy who violated the law. Okay? So the stigma that goes with the conviction of the criminal offense and may also damage the reputation of the offender. Also, that in the absence of fault, instead of imposing strict liability, offenses could contain a requirement of negligence. And they say that this would ensure that the defendant is only convicted if he fails to meet the objective standard of the reasonable man, reasonable person. Remember, we read about it. They say the age, the sex, the environment the person is brought up, the education, whatever the scenario is relating to the facts relating to it or the historic traits relating to it, they should be, he should be treated objectively according to a reasonable man of the like of this defendant would have done the same thing or not in the same circumstances. That's the objective standard. Okay, another possibility is that the statutes contain a defense of due diligence. Either of these alternatives could remove some of the harshness of strict liability. Okay, so there are arguments on both sides. If you get a question on strict liability, just to ask the question, this would be a great point to mention. If they want you to argue whether, for example, if they say just comment whether strict liability should be criminalized offense or the statuted offense or not, you can give both sides of arguments. Okay. What is vicarious liability? Usually they say that a person is only liable for his own act. Generally, a person may not be liable for somebody else's act. Vicarious liability is an exception to that general rule. Okay. It imposes liability of the defendant for the act or omission of another person. I can be liable for something somebody else has done. Okay, it's called vicarious liability. It's an exception. It's prevalent in tort of law of torts. For example, respondent superior, you will see a lot of cases of respondent superior in the tort. What is respondent superior? It is that a superior or a boss or your master or your chairperson or whoever, CEO of the company, would be vicariously liable for the torts committed by their employee. The employer, it put the employer under the liability for the torts of his employees if that tort is committed within the job description. It was within the job description and it was not a personal crime or tort that the employee has committed on his own time. He is at job, he is at work, within the job hours, within while he is working and obeying all his job duties, he commits a tort, your employer is going to be liable. However, although the concept of vicarious liability applied in civil law, it does not usually extend to criminal law, but there are two exceptions to this rule. There are two rules that they call it the delegation principle and the attribution principle. Okay, what is the delegation principle? Delegation principle is where the defendant can be criminally liable for the acts of another person, where he delegates the defendant, the employer, who delegates the duties imposed on him by law to that other person. For example, a manager, the boss tells him to do something or not do something that is against the law. For application, there should have been complete delegation of authority. There should not be partial delegation. He should have the complete authority to carry over the business or to carry over all the job duties that he is supposed to do. For example, there was a case, it's called Allen versus Whitehead in 1930. The acts of the manager in a cafe made the defendant, the licensee of the cafe, the employer, criminally liable for permitting prostitutes to gather on premises. At that time, the law said that you cannot let prostitutes gather on any on the premises of a certain business area or a cafe or such. This action was contrary to Section 44 of Metropolitan Police Act 1839. In this case, accessories was present because the women were allowed to gather on the premises, but the mens rea of manager was imputed to the defendant. Okay. What is imputed? If you don't know, I will just explain a little bit. Imputed means something that represents, something that is unrepresented, that is undesirable. For example, in this case, it was something against the law, and he did that despite of the clear instructions that do not do that. Something that has been done or caused or possessed, assigned to, for example, the action of others or assigned goes over to the other person. If I do something, somebody else is going to pay the price for it. That's what your imputed to means. Okay, so in that case, defendant was liable because really he was the licensee of the cafe and he put the manager in charge who was working in cafe and told him that this is against the law, don't do it. But he let that happen, and hence the defendant was charged. Okay, now attribution principle. In this one, the employer may be held responsible for the act of its employee. Again, same thing, but it applies to strict liability offenses. London Borough of Harrow versus Shaw and Shaw in 1999. The sale of national lottery ticket to a person under the age of 16. In this case, what happened was that the duty of selling the lottery ticket was given to these people, and they were told that it's against the law to sell these lottery tickets to a person who's underage or the age of 16, but yet they did it. And it considered, although it was not a tort or anything like that, but he was still, and the liability was attributed to the principal. Okay. The difference between attribution and this is in the delegation principle, employer is the licensee was completely out of the business. He was just watching over, and the manager was in complete in charge of the cafe. Here, they were given the tickets. They were not the only one who were given the tickets. There may be 10 other people who were selling those tickets. There was no complete delegation, and they were just supposed to do something for this other person who is the defendant, and they didn't completely comply with the rules and regulations. Okay. Okay, what is the corporate liability? It relates to, obviously, as the name suggests, relates to corporation, and you must know that a corporation may sue or be sued in its own name. A corporation is considered a legal person. Okay. It may enter into a contract, it can commit a tort, or even a criminal offense. You will read about it in tort again. It also is a little tiny subtopic in your homicide. I may have mentioned in my notes, if you look at the summary of the notes, there may be a mention of it. A corporation may be committed of a criminal offense, though the application of the identification doctrine through the application of the identification doctrine. The liability of a criminal offense must be found against an individual on the board of directors or the senior management. Not everybody in the company can be held liable. For example, not all the shareholders maybe. I have one share in the company. I cannot be held liable. But the people who is the major shareholder, for example, the people who is on the board of directors, person who is a CEO, person who has started the company, Okay, these people can be held liable, the senior management, in order for the corporation to be convicted of an offense. There have been a few successful prosecutions against corporations in the past, and recommendations to reform for this law aimed at the holding corporations to account for negligence, which leads to loss of life, have culminated in the enactment of the Corporate Manslaughter and Corporate Homicide Act of 2007. This act actually came into force on April 6, 2008. The act abolished the criminal liability of the organization for gross negligence, manslaughter, and created a new offense of corporate manslaughter in England and Wales. Okay, just a brief history there, in case you have to make a point of that. That is all for the liability. That was, it was just like I said, it was very short and brief. Anybody has questions on liability? Okay, I guess not. Let me upload the other file up here. All right, we are on to criminal laws of rape and sexual offenses. There are two types of sexual offenses. Rape is considered separate than the sexual assault. We're not going to talk in detail about sexual assault today. We're just going to touch upon rape, and in the next lecture, I will briefly explain to you or in detail, however needed, sexual assault. And I will tell you also, I will look at it and tell you that what part or up to what extent it's tested in the exams. Okay. Briefly, a little bit the background, because it's important. There was a lot of reform in the rape law. In 1999, the law for sexual offenses underwent a comprehensive review, resulting in a significant reform brought in by Sexual Offenses Act of 2003. This is the most recent one out there right now. Before that, it was several different statutes, and they were just principally under different statutes were gotten together principally under the Sexually Offenses Act of 1956. And it was in place since 19th century, so it was pretty old, and they were still using it up to that point. In July of 2000, the Home Office published the results of its review of the law on sexual offenses in its paper called Setting the Boundaries, and it was titled Reforming the Law on Sex Offenses. It has 62 recommendations, most of which were incorporated in the White Paper of 2002, entitling Protecting the Public. And it said strengthening protection against sex offenses and reforming the law on sexual offenses. So finally, Sexual Offenses Act 2003 came into force on 1st May 2004. And it's not main piece of legislation, and it is the main piece of legislation repealing most of the previous laws on rape. So assault by penetration, sexual assault, causing a person to engage in sexual activity, defines the law of rape and introduces for the first time the definition of consent. It also created 4 new sexual offenses. For example, sexual offenses against a child under the age of 13, rape of child under the age of 13, that is defined in Section 5. Then there was assault of a child under 13 by penetration, that is Section 6. Then you have sexual assault of child under 13, Section 7. And causing or inciting a child under 13 to engage in sexual activity. Now, you can see that how many variations it touched upon. Even before that, before this law came out, it was the reform for the regular or the not the new sexual offenses, but the other sexual offenses, for example, rape, marital rape, and can a man be raped? All these questions were discussed and they were being debated on for a long time. And they slowly reformed and made new rules and law. And that's what common law does. It constantly updates the law as the new situations come about. So this one also created various child sex offenses under Section 9 to 15, which apply to sexual acts committed against complainants under 16. Now you see there's a separate section for kids who are the victim of rape under 13, and there's a separate section for kids, the children who are raped or victims, and the complainant who are under the age of 16. Right? It was just the background. Okay. I copied here the Act of 2003, Section 1 of 1, 2, 3, and 4 of the causes of the rape offenses. That is also mentioned in your guide. It is also mentioned in your statute, and it has also been talked about in your book, obviously. I'm not sure how many of you have read, but I would like you to take a couple of minutes and go through this statute. I'm going to leave it on screen for a couple of minutes. Funny thing about statutes is you cannot understand most of the statutes in your first read. That's why I like to give you time. If you haven't read it first, during your read next lecture, you can read it again. It's very important to know that if you find it repulsive, don't read it over and over again, because you will see that there are many variations in many situations that come out, and sometimes those things are not mentioned in the statute, and then people or the lawmakers, they have to sit down and decide whether to deal this situation. How do you deal with this situation in terms of the act? That's why these acts are, or the law is written in a very specific language, and sometimes they are very, very, very defined and long and really mouthful to read. I'm not going to read over it again. I understand that everyone has read it. So keep that in mind, whatever they talked about in this, and we're gonna discuss these one by one and look at it. Okay, moving on. Rape. Okay, rape is a serious sexual offense. It is indictable only and carry a discretionary maximum sentence of life imprisonment. Now we talked about discretionary maximum sentence of life imprisonment in homicide a lot. Can anybody out of you tell me what does that mean? What is a discretionary maximum sentence of life imprisonment? Curdy? Well, it can be based on judge and jury's discretion to do what? Okay. 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 So life imprisonment is going to jail for life, right? Maximum life imprisonment is that obviously you can go over, because if it's life imprisonment, there is nothing after that. You're going to die in jail. A defendant is going to die in jail most probably if he has a life imprisonment. When they say discretionary maximum sentence of life imprisonment, does it mean that it is the discretion of the judge and jury to give him the life imprisonment or let him go free? Okay. Not free, right. Okay. Complete life or the less. The way you want to draft it, good. Thank you, Sandeep. The way you want to draft it is what Sandeep said is correct, and you want to write that it's in the discretion of judge or the jury, depending on the status of the court and the crime it is, that they are going to give the sentence up to life imprisonment. They don't have to give life imprisonment, but they can if they want to. Okay, that is the maximum. There is no minimum in it. You can give 1 month, you can give 1 year, 5 year, 10 year, or 30, somebody said, or even life imprisonment. Nobody is going to ask you, depending on the case and the jury direction of court, depending on the statutory sentence, depending on what kind of offense it is. Reduce the term served after minimum, that goes with the life sentences in general, yes. And the discretionary part remains there while during the conviction or sentencing hearing, they can decide whether to give this man a 5 year in jail or the life imprisonment. So it's discretionary to them, really. If it holds the conviction of life sentence that is discretionary, you're not under an obligation to sentence him to life. Provision under Section 1(1) of Sexual Offences Act 1956, which was the old law, which simply stated that it is an offense for a man to rape a woman or another man. This is very specific. They only said only a man can rape another woman. Only a woman can be raped. They didn't say, they didn't describe it any other way. But what 2003 Act did, it was gender neutral. How it was gender neutral? That it did not define that, it did not use the word man or a woman or men and women. It just said that uses A and B rather than the word, like I said, man and woman, and far more specific with the element of crime as well. The previous law was very general. The offense of rape under Section 1 SOA 2003 can only be committed by a man, not by a woman, although a woman can be convicted of rape. How is that possible? What do you think about it? It says that it can only be committed by a man. It doesn't, well, it doesn't really have a word as for the defendant to be a man. It says A and B. It is open to both genders. It's gender neutral. Yeah, but it says that it can only be committed by a man as a principle. If a rape can only be committed by a man according to SOA 2003, then how does it say that a woman can be convicted too? In what category? A woman cannot rape according to the specifications. Okay. If you guys are replying in the chat, I highly suggest and recommend that please open your chat to everyone, so everyone else can see your answers too, because we are all benefiting from each other. Okay. If I have to reply or comment to your answer, I don't know if I'm supposed to say it out loud because it's coming to me privately. It can happen indeed, yes. We'll see how. Hmm. Keep talking. If you like, I can mute my mic. Give you guys a couple of minutes and you guys can open your mic and I'll tell you my take in the end. You guys discuss among yourself for 2 minutes. I want to listen to you first. I can't hear you. Do you guys not want to talk? Okay, fine. I'll go then. Somebody mentioned the woman can be convicted as an accessory to rape, and that is correct. They can be convicted as an accessory to rape in one situation primarily. Yes, a man can only be convicted of rape because your act defines that it's the penetration of the penis into the vagina, a mouth, or anus of the other person. Okay, since the women naturally don't possess that, they cannot be the they cannot be principally convicted to rape, but they can obviously be an accessory. For example, inciting somebody. For example, there was actually a case where girls in school had bullied another girl to have sex with another boy, and they were convicted as an accessory to rape. What else they can do? They can be part of. They can help the rape. They can assist the rape. They can abet. They can, kind of try to hide there can be many ways they can be an accessory. Yeah, so just because you are a woman and you do not have a penis, that doesn't mean you cannot be convicted of rape, okay? Now there is another situation where a woman can be convicted of rape as a principle, and we'll touch on it later on. I don't just want to give it away right now. Okay? Now, what are the elements? A female who is being raped is going to be a victim. It depends who is the rapist, and it depends how it has happened. And if the other women in the rape has assisted the rapist, yes, they are going to be convicted. When you say a female in prison who was raped, that makes her the victim, not the rapist. The rapist is the female. It depends how it has happened. Did the female? You tell me how can it be? Carrie Ann? Yeah. Now we're talking. I really want you guys to right now open your mic, unmute yourself, and talk about it. One by one, just be civil. Go on and do it. One person, two people at a time. Carrie Ann had a question, and somebody, I think Andrea, had another one. How can a woman be criminally liable for raping another woman? Go on.
Come again, what did you say, please? What was the question?
The question is written right there. One of your friends have asked that how can a woman be criminally liable for rape? Somebody who has been raped in prison by another woman. And somebody else also had made a comment as a question that Andrea is saying that what if a female has a gender reassignment? I mean.
Well, my take on that is that, if there is no act that makes a woman criminally liable for committing such an heinous crime, how can she be held responsible for such act? How can she be held responsible for that when there is no act that makes her criminally liable? Does that mean she must possess a penny before she can be before the sexual offenses have entry can be invoked on that? I mean, how does it really work? And there's a very good that's very good input as well for someone who has a different who took away for example, a woman who takes who slices a vagina off and has a penis and panties and all that. Is he or she, I mean, how is he gonna be referred to in the act? As a he or as a she, or the she-male? Do you get my point? Or do you want me to read away? Because it doesn't confuse me here, because the act strictly applies only to men, and it doesn't cover women or transvestites, or I mean, it's like it allows some other forms of people to perform a certain act while a certain gender cannot. I mean, but if it's forcefully penetrated, then according to the House, it's rape. Anyway, my question is, can a woman be charged for rape? Just because there's no act that makes them criminally liable does not mean they can. I cannot find any act that correspond directly to that. So anyone want to help out?
Okay. Thank you, Femi. Carl made a good point, but Carl, what about a person who's undergoing a reassignment or changing of gender surgery, which is in the layman's term, it's called. Yeah, you're right. If it's a woman and is undergoing a surgery, he cannot be placed in the women's prison. What about if a man is undergoing a surgery and to become a woman, but the surgery has not completely done, or vice versa, or woman is going into the transgender transformation of gender, and it's not completed yet, but she has the surgical surgically put in the male reproductive organs on her. She has a penis now. And then if she is a woman primarily, then she would be put in the female prison, right? Somebody also made another comment that you can be raped by an object, anything other than a penis. What about that?
You have? Hello. Am I still subject to talk? Or should I communicate?
Okay. Okay, who wants to, out of, can anyone hear me? Everyone hear me? Okay. Who wants to, out of you all, would like to carry this discussion over and to just put it down in a little paragraph and carry this discussion over to the Facebook group, and we can continue to discuss it over there. Anyone? You want to do it, Femi? Thank you very much. You can start a new thread in the Facebook Criminal Law group. Anybody, like I said, who are new and who have not joined the group, please go on and go ahead and send the request, and it will be approved immediately. And we can carry this discussion over there. I am very glad that for the first time since we are delivering the lectures on criminal law, pretty much everyone has spoken and had this kind of discussion. This is what I want. This is how you go into the analytical reasoning and the brainstorming. We're going to stop the lecture right here, and we're going to carry over the discussion over to Facebook. And Femi has taken the responsibility to start a new thread. I will participate myself as well and pitch in with the little pointers. But the main discussion is going to be with all you guys. Anybody who wants to join anytime can jump in. But it will be great to see everyone join the discussion like it's going on here, and it's very fruitful, I must say. Okay, I'm going to sign off right now. We are on the elements, slide 5 of rape. Next week we're going to carry it over to the we'll continue to discuss rape and then sexual assault from there, and we'll finish with sexual offenses. And I am giving you the link, pasting the link again for the group. Here it is. Owen. You're welcome. So I guess I'm just going to sign off now, and I will see you guys on Facebook. You're welcome. Owen, is that your first time attending? Happy holidays, Casey. Next week, perhaps? Oh, by the way, there is no class next week. Enjoy your holidays. And welcome aboard, Owen. And anybody else who is here the first timer, welcome aboard. And we'll see you guys on Facebook. No lectures next week. I will post a few, there is a document that I read on rape law during the marriage, or the marital rape, it is called. I will post that later on. We have not touched upon that topic yet, so I will hold on to it for a little bit. Again, if anybody else who has not sent me the question, please go on and send it. The links for the YouTube videos have been sent through your email. I cannot send you a link over there, and it comes directly from our technology department who upload the videos there. And I will send your, I will convey your message over there if you have not received the link. We will resend it, but it's going to be to your, and preferably the Gmail account. I will advise the department, Carl. Thank you. Okay, people who are new, or they have the first time here, tomorrow is a public law lecture and common law lecture that starts at 7 a.m. California time. So check your local time. Okay, Casey. Check your local times, and whoever gets the link, please come in and join, okay? And again, happy holidays. Have a happy new year and Merry Christmas. And I will see you guys back after the holidays. Okay? All right.